how to avoid the first-headed monster and the third-headed monster, probate court and bloodline protection for my children. Oh my. Hey folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, got a great question today from a subscriber. Sent an email. Hey Patrick, what's the best estate plan when you have minor children? Minor children. Do we need a will? Do we need a trust? And what should we consider? Folks, pull up your chair and get your pen out. Because if you have minor children, or if you know someone, like your children who have minor children, your grandchildren, they need to know this, okay? Folks, when you have minor children, you do not want a simple trust, right? You need a trust that has protections in there. And the protections I'm referring to when you have minor children are guardianship protection plan, a guardianship protection plan. What I mean by that is if you have children here in the Commonwealth under 18 years of age are considered minors, right? If something happens to you, you get hit by the bus of life, they are not going to be able to legally touch your assets because they are minors. They're going to need a conservator appointed by the probate court judge, maybe a stranger it could be. You don't want that managing your minor child's money for them, okay? So what you need to do, folks, step one of our three-step process, meet with your estate attorney if you have minor children, okay, and design a plan around protecting them. What I mean by that is you need a guardianship protection plan in there when you have minor children, and you need to memorialize that in writing under the guardianship protection provisions, okay? And you put that right in your will, you put that in your trust-centered estate plan saying that if the parents got hit by the bus of life, if mom and dad went out to a movie and a show and dinner and God forbid they got into a catastrophic automobile accident. I actually had a case like that years ago, no names of course, it was catastrophic, it was a tragedy. And if that's something like that happened and your minor children are left without parents, you need to have everything protected in your treasure chest, okay? And then you need to have the players on your team pre-appointed that can legally step into your shoes day number one as the legal guardians, okay? And if you're parents with minor children, you need to have this tough conversation to say, if that situation, that tragedy ever struck our family, who would be the most suitable surrogate parent for our children, right? Is it the grandparents? And if so, what side of the family? You need to think about that. And if you can't come to an agreement, I would strongly recommend you need to pick someone and you need to memorialize that, because if you allow the probate court to make that decision for you, sometimes your worst pick is better than their best guess. And then in addition to that second layer of protection, you need belts and suspenders. Massachusetts actually has a Massachusetts general law on appointment of guardian. You need to sign that and appoint that as well. Memorialize it in your plan, sign your trust, design it and sign it. But number two, also sign the Massachusetts general law. Massachusetts, again, has a guardianship law where you can say, if we check out unexpectedly, prematurely, we want so-and-so. We want grandma and grandpa, Bill and Mary, being our court-appointed guardians, right? That's extremely important. Then, folks, after you get all the written protections in place, step one, step two, you need to get all the treasures in your treasure chest, right? So when you check out the house, the life insurance, the retirement accounts, they cannot go to your minor children. The financial company legally cannot give them a check. So you need a trustee is the other big role here. Guardian we just talked about to manage medical and educational affairs and events, to be the surrogate parent to help raise your child the way you want them raised. Now we need the second head right here is trustee. Trustees to manage the money. To manage the money. What house are they going to live in? How are they going to pay for it? Well, we got life insurance earmarked. Well, you got to get that life insurance in step two, funded to your trust. More specifically, the financial company is going to cut the check not to your minor child, but to your trustee. And the trustee could be the same people as the guardians, because we trust unconditionally Bill and Mary, your parents or the grandparents. They have the wherewithal. They have the acumen to manage the money, right? If they do not, you're the expert on the family. You pick someone. It could be your sibling. They're an accountant. They're a CPA. They're an attorney. They're a financial advisor, all right? But they're good with money and they're trustworthy. And they can manage that money, invest that money so it continues to grow for the health, education, and maintenance and support of your minor children. And then when your children become a certain age, you can put that language in there. Then they can start to manage their own money. Maybe when they're 25, after they receive the formal education. It's a wait and see approach. You have to see whether they have the ability and the intellect and the acumen to manage their own money responsibly and prudently. So you need to put all that in there, folks. Otherwise, you're putting yourself at the devices of the probate court, and they're extremely busy places. They don't always get it right. Another piece of guardianship protection plan, you can put motivational or incentive matters in there for your guardians to say, hey, I want my kids to go to private school if we have the financial means to do so. I want my kids to participate in these activities, these sports, or avoid these type of sports because of, their contact sports. You don't want your kids to have concussions or whatever the situation may be. But you want to memorialize how you want your surrogate parents, the legal guardians, to raise your children, whether it's your religious beliefs or your academic beliefs or your other values. You can put that in your plan as well, folks. All very, very important considerations. But before you overthink it, you need to take action. Make that appointment with your local, qualified, experienced estate elder law attorney and put that plan into effect. Put it into action right away. Folks, hopefully you found this video helpful. Please scroll down, leave a comment, a question, and a member of our team will get back to you as soon as possible. Be sure to click the subscribe and notification buttons, and I strongly recommend pick up a copy of my book on Amazon as well. Attorney Patrick Kelleher, How to Slay the Four-Headed Beast of Estate Planning and Elder Law. Folks, great to see you. See you next time at elderlawcare.com.